earlier this week, I think it was on like Monday, maybe it was Friday. I think it was Friday of last week. The judge said that he had it on good authority that sensitive information regarding something with Michael Proctor that was impounded was leaked. And he needed every single attorney that's assigned to this case, and it's like 30 of them, in person in his chambers on Wednesday. That's yesterday, right?
Yeah.
They all show up. Alan Jackson had to fly in from California. The two attorneys working with Alex Jackson, they got to do it by Zoom. One attorney was excused, but I'm going to play that hearing.
Okay.
Oh, I just clicked on the wrong thing. Way to go, Aaron. Okay, I got it from the trial channel. They download these and then cut all the crap out, which is great.
Yeah.
Let me show that. Oh, you can see that?
Yeah.
This court now
That's fine.
May I proceed?
Yes.
For the record, civil action 2483 CV 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as CF McCarthy's et al. Your Honor, with your permission, at this time, I will call the names of the attorneys in attendance and ask that they state that they are present for the purposes of the record.
Thank you.
Attorney Brillahante.
Present, Your Honor.
Attorney Horwitz.
Present.
Attorney Fell.
Present.
Attorney Buck. Present. Attorney Diller. Attorney Beaton has been excused, Your Honor. Attorney Holstag.
Present.
Attorney Rose. Attorney St. George.
Present, Your Honor.
Attorney Donovan.
Present, Your Honor.
Attorney Daly.
Present, Your Honor.
Attorney McCaffrey.
Present, Your Honor.
Attorney Hassett.
Present, Your Honor.
Attorney Maravellis.
Present, Your Honor.
Attorney Shipley has been excused. Attorney Tang.
Present, Your Honor.
Attorney Bell.
Present.
Your Honor, Attorneys Little and Mason are appearing by Zoom.
Yes, Your Honor. Present.
Present, Your
Attorney
Honor.
Jackson's getting some free publicity as well. For
Attorney Jackson.
A lot of people got really offended that he said that, and I think Alan Jackson did too. But what they didn't see was the Zoom screen that the judge is looking at. And if you look, it says Worksman Jackson and Quinn really big on the wall behind the attorneys. So I think that's why he made that comment. He wasn't deliberately trying to be rude to him.
It's still rude.
Present. Attorney Seligson.
Present.
And Attorney Rosenberg. Present, Your Honor.
You can sit down. Thank you. So thank you, counsel, for being here. I scheduled today to be in person because of the significance of what I was advised of last Friday, and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function. One comment there describes how every high-profile case now unfolds in two arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms, and how the courtroom has become content and the law has become a spectacle.
Okay. How do you feel about him saying that?
I mean, I don't think that the external factors that he's referring to have an influence in the actual courtroom in like an ideal sense. So I don't really know what the point is.
Yeah, I don't either. This guy's so boomery to me. And like, you know, the public has a right to know what's going on in these trials because we're paying for them. We pay his salary.
Yeah.
We pay the prosecutor's salary. Like, what are you talking about? You need to have transparency, especially in a state as corrupt as Massachusetts.
Right.
I recently held a hearing on a non-party motion for a protective order. I required the moving party to provide certain information. Such material was filed together with a motion to impound. A hearing that included the motion to impound was held on Monday morning. I allowed the motion to impound during the hearing. The affidavits of the moving party and the attorneys were impounded. Following that morning hearing, I found that there was insufficient information to support a delay in the deposition of the non-party from going forward. However, I further found that given the claims made in the filings, I would delay making a final decision on the motion until later that day to give the non-party's counsel the opportunity to supplement the record before me. I scheduled the matter for further hearing that afternoon at 4:15 with the expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court and all counsel of record, excepting one, additional materials in support of the motion for a protective order. The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information, similar information to what was in the exhibits to the filing and marked provisionally impounded, was posted to an X account at 2:52 p.m.
Okay. So you heard that, right?
Yeah.
All right. So let me see if I can find it. Yep. So I'm going to share exactly what he's talking about on X.
Yeah.
And this is just him being a boomer and an idiot. Okay.
Yeah.
So he tweeted at the time he said, on the date that he said, Michael Proctor decided to have a mental health crisis after the whole world found out how racist he is. Sources tell us he checked himself into a mental health facility in Florida to try to avoid today's deposition. Now, he had talked about this already 2 days before on a live stream.
Right.
Okay,
right.
so he already knew because it was leaked. It
Yeah.
was leaked by Michael Proctor's stupid wife.
Right.
So, like, how can they be? He's just doing journalism. Turtle Boy's doing what he's supposed to do. This judge is a freaking idiot.
Yeah, I don't disagree with that.
Like, he just doesn't. He doesn't get it.
No. So he thinks that somebody was in cahoots with Turtle Boy and gave him this information. Is
Yeah,
that
he
what
thinks
you're arguing?
one of Karen Reed's attorneys leaked it to him. This impounded stuff. When the fact of the matter is, his source knows Elizabeth Proctor. And she told him this. This was before anything was impounded. This was before any of the documents were filed. And we all were speculating he doesn't want to show up because he's going to say he's having a mental health crisis.
Right.
Upon learning this information, I ordered that the parties and counsel provide a certification to the court as to all facts known to them as to any dissemination to anyone other than parties and counsel in this matter. Of any of the content.
I also want to point out that he said that it was sent to him. Sent to him by who? Michael Proctor's attorney?
Probably.
That's some sabotagey stuff. A lot of the time, these judges will have their clerks like alert them to stuff like this.
Yeah.
And that's why I made that joke early that Becky Hill was working in Massachusetts.
Yeah.
Because this is so ridiculous.
Of the material impounded on June 8th, 2026, and I scheduled this appearance for today. I received certifications from all party and counsel, 32 of them in total. No one apparently has disseminated, nor are they aware of any facts regarding the dissemination of the contents of impounded material to any person or entity other than the parties and counsel in this matter. However, somehow, an ex-account holder, not part of this case.
An ex-account holder. He won't even have he should have sent them all a message saying explain this.
Yeah, he called them all into court to waste their time to basically
And money.
chastise them.
It
Yeah,
was expensive for Alan Jackson to get there, and Karen Reed has to pay for that. How is that fair to the defendant? How is that a fair? It's not.
yeah, he's being a real. This is a real
Boomer.
boomer. He's like, I'm gonna call you all
Apparently
into court.
received information that was at least provisionally impounded. Orders of the court have been violated either directly or at the very least in spirit. If these orders are to have any effect, all parties involved must operate with integrity. Rule 13C of the Uniform Rules of Impoundment Procedure imposes a duty on all persons to protect the confidentiality of impounded material. Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding.
He already had this prepared. Like, he had a prepared statement. He just wanted to give them all a dressing down. And
Yeah,
I mean, we may as well put an egg on this guy's face. Maybe we'll do that later and make a little fun video out of him.
yeah,
In cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30. To any issue counsel may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases. In the 2003 case of Buster v. George W. Moore, Inc.,
I wonder if they can bring up any cases of a judge being a boomer and completely wrong and ask him to familiarize himself with those.
yeah, right.
438 Mass 635. The SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge. In a 2002 appeals court case, Mattoon versus the City of Pittsfield, 56 Mass App Court 124, the court stated at page 131, trial judges have broad discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial. In the 1987 case of Solomon A. versus B. Gruhl, 399 Mass 790, the SJC stated at page 799, the conduct and scope of discovery is within the sound discretion of the judge. In Cronin versus Strayer, 392 Mass 525, a 1984 case.
This is incredibly prejudicial because he's basically accusing Karen Reed's attorneys. You know, the other people are just there to make it seem fair, but that's what he's doing.
Yeah.
The SJC stated at pages 535 to 536, we remind judges that the scope and timing of discovery is within their discretion, and the prevention of discovery abuse is sufficient justification for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the 1987 case of Campagna versus the Board of Directors of the Massachusetts Housing Finance Agency, 399 Mass 492, the SJC stated at page 503 that Rule 37 affords a judge broad discretion to impose whatever sanctions are just in order to ensure that the discovery process operates efficiently. The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party, even if warranted, such an opinion does not allow for the disparate treatment of such individuals.
By the public, we can say whatever we want.
All people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic, as abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rule for pettiness and profit. If the parties and lawyers would enter into an agreement to hold private.
For profit, that's ridiculous. I will say, I see some pettiness, and it's by this judge.
Yeah.
Personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction, including dismissal or default. Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative.
I mean, maybe he should familiarize himself with those because clearly.
To publicity. The rule sets forth a basic general prohibition against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood on materially prejudicing an adjudicative proceeding. The rule applies to lawyers who are or have been involved in the investigation or litigation of a case and their associates. As the comment to the rule notes, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some curtailment of information that may be disseminated prior to trial, especially where trial by jury is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence. The rule takes into consideration that the public has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. However, I'm not so sure that churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings.
I mean, who's doing things to get social media coverage?
He's really convinced himself that he's uncovered some underlying conspiracy that he now gets to like call out in his courtroom, when in reality it's just an underground journalist.
Read the rule, especially if you have never done so. Adhere to it, or be ready to face the consequences.
Read the rule, especially if you haven't done so. Of course they all have. Of course they all have read the rule. Like, what a condescending thing to say, especially when, you know, this is his mistake.
For failing to do so. I remind counsel of what one commentator called the quiet expectation of fairness that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain. Counsel, do your part to maintain the quiet expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what a trial lawyer should be, one that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God. I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy. May it continue to succeed with all of us working to maintain the rule of law. Thank you.
Court, you all right?
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on motions to compel the criminal fourth session.
Well, waste everybody's time.
Court stands in recess.
There's no opportunity to be heard? There obviously no opportunity to be heard.
I was unaware. I'm just covering for Clark Donovan today.
That's a
Is
terrible.
there an opportunity
Yeah, what kind of hearing is it when you can't be heard?
before anybody departs to let the judge know that we would like to be heard?
Absolutely.
Thank you.
See what else they have. They're showing the empty chair. Okay, so the entire end of it is just like the empty chair.
Yeah, I mean, that guy wasted everybody's time just to make himself feel like he's the boss and he's in charge.
Yeah, I know Grant Smith Ellis did an interview. Let me see if I can see it. Look at his X account. He posts so much, so it might take me a minute. He's like covering the war, and he's covering the war a lot.
I have no idea who this person is.
Oh, that's a whole other story. He used to be a bad guy, and now he's a good guy. All right. Where is this? I might have to go to his YouTube. Hold, please. Oh my gosh, he just goes live all the time. Videos. I don't even see it now. Anyway, basically, Grant was outside. So were some other reporters, and they wanted to get a comment from AJ, and he was just like, I can't say anything. Nice try, but sounds like I shouldn't say anything.
Yeah.
Absolutely ridiculous.
Yeah, I agree.
So I'm not going to go over the rules of professional conduct that he gave because, I mean, who cares? Honestly, it doesn't matter.
Yeah.
But Turtle Boy has 6 pending witness intimidation charges, each carry a maximum of 10 years in jail.
Yeah.
And 4 picketing charges, each carrying a maximum of 2.5 years. So I'm going to move on to this guy.